Dramatic turn of events this week in the Senzo Meyiwa murder trial. Hello and welcome to Inside the Courtroom, the Senzo Meyiwa murder trial wrap. I am Linda Nisi. Now, of course, we're live to you from our Randburg studios in Johannesburg. Thank you very much for joining us for another wrap this week. Let's get to it now. As you know, every week we do have a poll and ask you some certain questions relating to, of course, what has happened in the trial. This week, we're asking about what you make of the allegations of an assassination plot against key role players in the trial. And some of those options that we have for you is they should be taken seriously. The second one being, I do not believe them. And the third one being, the trial should end already. We'll have that poll up where you can, of course, scan the QR code on your screen and start voting. But you can also engage with us on our social media platforms. That's at Newzroom 405 to vote on that particular poll. There you see it on your screens. The allegations of a plot to assassinate key role players in the Meyiwa murder case, and those options on your screen. So make sure that you start voting and, of course, engage with us on our social media platforms. Let's get to it now. The court was meant to kick off proceedings with arguments on the proving of a statement made by current witness Swiso Zungu, also known as Gwabini, when there was a dramatic turn of events. Gwabini alerting the court that some of the people he came with had been taken by the police.
Witness has just drawn my attention. I'm not sure.
Yeah.
There are people who were in my company, my lord, and that were seated here. And then they've been now taken by the police, so I'm not sure as to what is happening.
No.
Just now, my lord. They took them and went right around with them.
So will they intervene? Are they arrested or are they taken? Which is which?
That's why I'm asking this court as to what is happening with that.
I don't know.
Is it please the court, may I request an indulgence just to find out as to what is happening?
Yes.
Now, Mnisi came back informing the court that there were developments which they could not place on record at the time.
There are some developments, my lord, around the case which are not worth mentioning on the record. We would have actually also approached the court with a request that we adjourn. So we try and deal with those new developments with our clients and then we take it from there.
What developments are those?
As I'm saying, my lord, they are not worth mentioning on record.
But they are worth this court adjourning.
Most certainly, my lord.
And they are not worth it. But they are still worth it so that the court must adjourn.
It's an indulgence that we're requesting.
Hello?
It is an indulgence that we are requesting because we need
but I must know what's happening because I don't know what's happening.
As I'm saying, my lord, there is something.
What is something?
It's a new development.
Have they arrested somebody? The police?
My lord?
Have they arrested somebody?
I would prefer, my lord, not to say anything on record with regard to this new development.
No, you must say it on record. Because here am I, I'm sitting here. I don't know what's happening. And you want to adjourn.
In any event, my lord, it's already tea time. It's time for a short adjournment.
I can sit through tea time. What's the problem? Mr. Ngumal, what's happening?
Unfortunately, my hands are tied, my lord.
What's happening?
As my colleague is indicating, my lord, that there are new developments.
What developments?
Which we wouldn't want to place them on record for now. We have to take instructions.
This court can adjourn without knowing why I'm adjourning.
The police later confirmed that they're investigating a case of conspiracy to murder and that the people removed from court were questioned. Communications sent to Newzroom Afrika also revealed that amongst the targets was the judge, prosecutors and the investigating team.
I can confirm that we have registered a case of conspiracy to commit murder. We have been investigating this particular case for quite some time. We did take 3 people in for questioning for further investigation and profiling. We can confirm that they have been released. So the reason why we took them in for questioning is that we received solid intelligence corroborated by gadgets and electronic devices that we have seized, that there are high-ranking officials that are being targeted in the Senzo Meyiwa trial. And evidence at our disposal is that these individuals attend court proceedings looking for the opportunity to take out, murder these individuals as they enter court or as they leave court. So the steps taken today to take in people for questioning was for us to be proactive. We cannot sit with information. If we notice or suspect that certain individuals fit the description of those that we are looking for, then we have a right as the police to take people in for questioning, profile them, and so on.
Mata further revealed that 4 people made a run for it when the police took the 3 in for questioning.
We are aware that there are about 4 individuals that when we started with this particular process of removing people from court, they then ran away and they were outside court at that time. So we have a duty and a mandate to protect everyone in this country, more especially those that are involved in this high-profile case of the Senzo Meyiwa trial.
Yeah.
We know that the case is at a sensitive stage now. The state has already closed its argument, and now it's time for the defense to also prove their case. So we are leaving nothing to chance.
She says police are hot on the heels of the 4 suspects and that at the same time security has been heightened and they're in talks with the NPA over these issues. Advocate Charles Mnisi would later come back to give details of what happened when they went out to investigate what was happening at the time when the 3 people who were with Gwabini were taken away. In a startling turn of events, he tells the court that they too are now subject to a probe for allegedly being complicit in the alleged plot.
There's information that was conveyed to us when we went to go and find out yesterday, subsequent to the request that was made to see the 2 gentlemen that are accompanying our witness here. There's a person who identified himself as an investigator in these threats or in these new developments which amount to security threats. He identified himself and then he said, and I'm going to repeat it on record, that they were targeting, that they were after certain individuals who were seated here at court, and they've been monitoring them for some time. But yesterday when they were about to approach them, they were no longer able to see them and that those individuals had disappeared. So they are suspecting that we are the cause of their disappearance.
Mnisi tells the court that he had also been informed that he likes interfering in issues that have nothing to do with him, which he views in a serious light and thinks they constitute a threat. He has now sought to be removed from the case pending the investigations.
Mr. Mnisi went on to consult security experts and otherwise. He has been advised that he should request the court to recuse or to excuse him from continuation with the case pending the finalization of those allegations. And I take that advice very seriously, my lord, because I will not be able to apply my mind on the facts of the case that we're busy with here, pending the finalization of those investigations. We're told that there's an inquiry document that is being investigated, wherein it is alleged that we're also complicit. So, Mr. Mnisi says he will not be able to apply his mind properly up until such time that those results of the inquiry document come up, my lord.
After the break, we discuss security threats in this matter with our panel, which includes Begazeli Benjamin from Judges Matter and National Association of Democratic Lawyers President Machini Mhlongo. Don't go anywhere. Welcome back and thank you for choosing to stay with us. We're talking about the alleged plot to assassinate key role players in the Senzo Meyiwa murder trial. And I'm joined by my guest in studio, Begazeli Benjamin from Judges Matter. And on our Zoom link, we're joined by the president of the National Association of Democratic Lawyers, that's Machini Mhlongo, as well as Chad Thomas from IRS Forensic Investigations. Gentlemen, thank you very much for your time. Because before I get to you, I want us to take a listen to what the judge said, this week. Pertaining, of course, the discussions were around the adjournment, but of course, he took an opportunity to talk about, this particular threat. Let's take a listen.
Yeah, we can start next year if you want to, if I'm still alive. Yeah, I mean.
Yes, it's 19 January.
Yeah. Hey. Remember, Mr. Nisi once said, when we were trying to arrange for the trial,
inspection in
road crew. Remember, and then Gininda kept on saying, no, you know what, we need to get the police organized, we must get armored cars and blah, blah.
Oh, yes, yeah.
And he said, no, man, why can't we just go out and then have the inspection in local? South Africa is not a banana republic. You remember?
Yes.
Now I can tell him South Africa is a banana republic. They want to kill a judge. They want to kill a sitting judge. Even in America, you know how America is violent. They have never killed a judge. In South Africa, the last judge they killed was Justice Cooper. Have you heard about that?
Begazeli, those words showing the concern really of the judge, but their role, and judges that is to adjudicate matters, fairly without any, of course, undue influence, right? Talk to us about what these threats mean.
Good afternoon, Linda. Good afternoon to the viewers and to my fellow panelists. These latest threats are quite serious. They're quite worrying. We should never have a situation where judges, magistrates, all presiding officers are threatened for any reason. And the fact that the police in this instance were able to pick up the intelligence and step in before that eventuality happened, I think that they deserve the credit. But Linda, unfortunately, it's not an isolated thing. We're seeing concerns about court security across the board. Just a few days ago, we heard that there was a shooting outside of the court precinct in Athlone in Cape Town. But we know that in October, there was an incident at the Esikhaweni Magistrates Court in Northern KZN. And at the same time, there was a new security protocol that was introduced in the Johannesburg High Court to try and beef up the security in the court. So it is a concern that we are having so many concerns around security.
Yeah. And if people are unhappy, talk to us about some of, the channels that they can go through. We know that if anybody is unhappy with a presiding officer, they can bring a recusal application.
Well, first and foremost, Linda, I think we don't know at this stage if these people were unhappy with the particular judge, and so that's why they threatened to eliminate them, because we know that as Judges Matter, we've done research, speaking to magistrates, where in our research report we published in 2022, out of a survey of more than 230 magistrates, we found that at least it was about 30-something% of them had responded to say that they've been threatened or harmed in relation to their role as judicial officers. And the purpose of those threats were to try and either make the case go away or to, once you remove the presiding officer, the likelihood of the case being enrolled again was slim. And so it did seem that at least in that context, the threats were trying to disrupt the case. But if you are disgruntled for any reason with how the judicial officer is presiding, there is a legal process that is there, and it's the process of recusal. But even there, you have to really conform with the law. It has to be substantiated. It has to either be a perception, a credible and reasonable perception of bias, or actual bias against the judicial officer. And it has to follow a legal process. Any sort of threat or harm, I think, is an attack on the rule of law, because at the end, presiding officers must preside without fear, favor, or prejudice. Fear is the most important thing.
Yeah. And actually, in my first question, those are the words I was looking for. I want us to come to Machini now. Machini, thank you so much for joining us. I mean, the allegations that the defense team here may have been complicit in these allegations of this assassination plot, surely that should be worrying, right?
Thanks, Linda, and greetings to you and to your viewers, as well as my fellow panelists. Indeed, I share the sentiments. If those allegations were to be proved to be accurate and to be right, that actually goes to the heart of charges of defeating the ends of justice, among others. But of course, these are mere allegations at the moment. But if they are, as I reiterate, if they are to be proved to be true, that goes into deeper than meets the eye. It goes into the heart of this case, and it will also mean that legal practitioners who are deemed and who are expected to be holding the highest, standard of ethics, they would, and they are officers of the court. That would have serious ramifications and implications on the matter itself.
Yeah, this whole debacle affected Advocate Mnisi, and he wanted to, be excused from the matter pending, of course, these investigations. He said he would wait until there is a final report to come back. Obviously, his well-being is important because he needs to be fit and proper, if I may put it that way, to carry out the instructions of the accused person. But ordinarily, is that how things would be done?
Look, allegations have been leveled, and the veracity of and accuracy of those allegations are yet to be tested. And we should, whilst on the one hand, we are cautious in terms of how we approach these allegations, but on the other, need to be careful not to be seen to be putting the cart before the horse, and be preemptive to an extent that any attempts to come up with ways of not proceeding with the matter, any excuse not to proceed with the matter, we should be mindful of the fact that this matter comes a long way, and the matter has to be concluded within a reasonable period of time when it has been enrolled and it's already running. It's a partly had matter. So such an action that is being proposed by legal practitioners should not necessarily be resorted to easily. It should be based on valid grounds to justify the matter being brought to a halt pending the finalization of investigations into these allegations.
Chad, let me come to you. We're hearing here that the accused may be involved. So that's the allegation, right? And we don't know how true that is. How often do you come across cases where accused persons are alleged to be plotting, against certain individuals involved in their prosecution?
Very good afternoon to all, and thank you for the invitation to join the panel. When it comes to an accused person, there could be an element of bravado where within the confines of the prison environment, they speak big and they speak to others as if they have connections on the outside that are going to take part in some or other activity that will bring their case to some kind of fruition without following the normal channels. And you'll often hear where witnesses have been threatened from inside prison, where investigating officers have also been threatened from inside prison. Going to the extent of planning an assassination of a judge takes it to a whole new level. But then again, we have to realize we're living in South Africa, which is a very violent society. We had a witness from the Madlanga Commission assassinated on Friday night. So assassinations aren't very far out of reach when it comes to what criminals have the ability to control. One looks at the prosecutors that were assassinated earlier this year in the Eastern Cape. One looks at the bomb explosion outside the Wynberg Madge Court a few years ago, the shooting of a witness outside the Athlone Court earlier this week. And one understands that it's very easy to hire triggermen out there. And it's good that the state is taking it seriously now, because what could have been perceived as just bravado and jail talk in the past can now be perceived as a very viable threat. And it's good to see SAPS taking action. And one must remember this is intelligence driven, and we need more of this type of work.
We're also hearing that gadgets have been seized, and surely those can help in really determining whether or not there is, in fact, a plot.
Definitely, and it's time for the state to be a little bit more transparent with us. We do understand it's an investigation and it is at a sensitive stage, but we want to find out whether it was somebody that was perhaps within the prison environment that informed on a plan, or whether it was something that was actually actionable, whereas people had been paid, a plan was in place, and that an assassination was going to take place. There's a big difference between talking big and actually having the capacity to follow through.
Because I want to come back to you, because, I mean, ordinarily, we're hearing here in this matter that security has been heightened. But in other circumstances, what would the judiciary do to protect judges?
So on a normal basis, when there's a security risk like this, there will be a threat assessment that is done by the police, and this is also done in conjunction with the Office of the Chief Justice in relation to the High Courts. And so if there is an assessment done and the judge needs protection, there are protection provided. We saw this in the Radovan Krecher case, for example, where the judge was provided with security both in the court and to and from home. But I think, Linda, there is a bigger question about to what extent is the state providing court security generally? I mean, in the last couple of years, there have been cuts that have been made to the security budget. We know that in certain of the high courts, the outsourced security services have been reduced to the point where in one high court I know, almost overnight, the security guards were reduced and certain of the entrances were not provided with that security. And so I think there is, other than just an isolated case, there does need to be a serious looking at the security environment in the courts, both by the Office of the Chief Justice, which is for the Superior Courts, and the Department of Justice for the lower courts.
Speaking of security, Chad, I want to come back to you. I mean, when you look at what we're being told in this case, they say there is an integrated plan, but what would that look like? Because we know that a number of people, not just the judge, but prosecutors as well, and the investigating team are people that are perhaps being targeted. So a proper plan really to address these issues. When recess, people are going home to different places. How would it work?
So it's a two-pronged approach. The most important is to have actionable intelligence so that you can try, disrupt, dismantle, and make arrests or neutralize the threat that's been made to the individuals. But of course, other people can pick up where those have left off. So you have to have close protection in place. And this is something where you have very well-trained people from the South African Police Force, specifically the Special Task Force, from the South African Defence Force. They've got a component within the military police. Even the State Security Agency has a witness protection and security division. Together with the NPA, these organs work together with a component within Hawks to be able to put together a team, identify safe houses, bulletproof vehicles, bulletproof clothing if necessary, and the right trained people. But that's when there's a high risk that's been faced. Obviously, going into the actual theory of close protection and how to plan routes, etc., is a very long conversation. But the most important thing is intelligence. And when you get intelligence of a threat, you protect the individual that is at threat, but you go out to neutralize the threat to that individual. And that's why intelligence is so critical in the South African Police Service.
Machini, this particular matter is like Atlanta Matese, at a critical stage, right? The accused, you have opened their case, they're calling their own witnesses, and we often see how volatile, for lack of a better term, the atmosphere can be in that particular court. How important is it for all parties to just, work together in harmony?
Look, that is quite important in a proper, administration of justice setup. It's quite crucial that all the stakeholders and role players within the justice cluster, in this instance, you have the prosecutors, you have the defense, you have also the presiding officer. It's quite important that there has to be that rapport and working together, particularly when they are facing this conundrum. And they need to work in unison to ensure that they discharge their duties as officers of the court without fear, favor, or prejudice, and to do so within the parameters of the law, of course. And whilst on the other hand, each of the role players they play their own unique roles, and the role of the defense in this instance is to ensure that they come up with a defense that seeks to act in the best interest of their clients. So it's quite crucial, Linda, that all the role players within this matter work together to ensure that this matter is finalized expeditiously without any unreasonable delays.
And Mbegazeli, we've run out of time, but I just quickly want to come to you. A judge is not merely an empire, and these are the words that Judge Rata Mokgotleng likes uttering in court. How important is it for the presiding officer to ensure that they control the proceedings and that we stick to what we've come to do?
So a judge not only has a constitutional but also an ethical obligation to ensure a fair trial. And in doing so, they are required to make sure that the case runs and finishes quickly, there are no unnecessary delays, but also the decorum of the court is maintained. Both from all sides, whether it's the accused, witnesses, the lawyers, prosecutors, defense, everyone has to be on check and everyone has to ensure that it's a proper trial. But at the same time, the judge must themselves control themselves. So they must also try to speak in a respectful way to everyone involved and make sure that everyone's dignity, whether you're the accused, the witness, or anyone in the court, your dignity must be protected.
Gentlemen, I want to thank you so much for your time. That was Mbegazeli Benjamin joining me from studio. He is from Judges Matter, and via Zoom link, that was the president of the National Association of Democratic Lawyers, Machini Mutlung, as well as Chad Thomas from IRS Forensic Investigation. So after the break, we, of course, will be getting into more of what happened post, of course, dealing with the issues of this alleged plot to assassinate key role players. But remember, we're running a poll on, the events that happened this week in the trial. We're asking you about what you make of the allegations of an assassination plot against key role players. Those options are on your screen right now. Number one, it must be taken seriously. Number two, I don't believe them. The last one being the trial should end now. So make sure you vote and you scan the QR code on your screen, but also make sure you interact with us on our social media platforms. That's at Newzroom 405. You can also give us a call or send us a WhatsApp. Those numbers are on your screen right now. All right, so after the break, we get into arguments by all parties that were involved in the, of course, the murder trial, but specifically relating to the alleged statement of the current witness, that's Sfiso Gwabini Zungu. So you don't want to miss that. Stay tuned. Welcome back, and thank you so much for choosing to stay with us. You're watching Inside the Courtroom, the Senzo Meyiwa murder trial. Remember, every single Sunday we run a poll on key events that happened in the trial. And this week we're asking you about what you make of the allegations of an assassination plot against key role players in the trial. We've got three options for you. They are still on your screen. The first one is, it should be taken seriously. The second one is, I do not believe them. And the last one being, the trial should end already. Again, make sure that you interact with us by scanning the QR code on your screen right now to start voting. But you can also engage with us on our social media platforms at Newzroom 405. That's our handle on social media platform X. Also on WhatsApp, you can call us or in fact, send us a message. The numbers are on your screen right now. So make sure that you interact with us on all of those platforms. Let's get to this now. Arguments in proving the statement allegedly deposed by Gwabini finally got underway later in the week. According to the state, Gwabini made the statement that gave information that potentially implicates him.
We submit that the point is that his explanation must be tested as to reliability through cross-examination. We submit that it's a credibility issue, my lord, as to whether his statement is trustworthy, and therefore that the statement itself needs to be examined through cross-examination.
Now, arguing from the bar, Advocate Charles Mnisi did, of course, say that the state did not address the issues of approving the statement allegedly made by Zungu.
I thought that the state would come up with something totally, something that is totally out of the realm of the ordinary, from the process that is known with regard to how a statement of a witness is being dealt with if the credibility of that witness is to be challenged, my lord. At the moment, I thought that the state would come up with an authority that says, no, there is an exception to the fact that before a witness is impeached on his statement, we don't have to prove his statement. I've gone through their heads of argument. There is nothing such as that, my lord. All that the state is talking about, they are repeating the evidence of Brigadier Kininda, which is already on record. They are repeating the evidence of Mr. Zungu, which is already on record. They are talking about the interest of justice that we all know. They are also talking about the evidence of Mr. Gwabeni that is already on record, and a whole lot of areas. But one point that the case is, that the state is missing is to come up with exceptional circumstances where a witness can be cross-examined on the basis of his statement without proving that statement.
Let's bring in my guests now. I've got legal analyst Kabelo Siabi, who's joining us via our video link. But in studio as well, I've got commentator Bongani Masuku. By now, you should know him. Bongani, thank you very much for your time. And I want to start with you, Kabelo. I mean, the issue around proving a statement, this is a defense witness. Ordinarily, we would see it with when a witness is called by the state laying the basis for going into, of course, that particular statement. But in this particular instance, the defense says, prove the statement.
Thank you, Linda. I think the departure point should be to understand first what is the purpose of the statement at this stage of the trial. Now, a statement could be used in various regards. There is a statement that has been made by an accused person, which during the trial, that statement could be introduced to be used as evidence in the trial. Now, the other option or the other thing that is open to usage of a statement and in this particular regard, is that the statement is being used in order to show that on a different occasion, the witness under oath, statements are taken under oath, that the witness said something different to what is being said during the proceedings. This is where the statement is used in order to deal with the aspect of credibility or trustworthiness of that witness's evidence.
And I mean, some of the things that we are hearing here are the issue around the arguments themselves, right? The state saying the issues here that we want to deal with are issues of the witness's reliability or credibility, rather.
Correct. The state is not trying to use this statement in order to advance the contents of the statement as being material that is to be considered in evidence. What the state wants to use the statement for is to show that the witness has departed from a version that they have previously given in the written statement. And what is of particular importance, again, that one must not lose focus of, is the fact that the witness, Sifiso Kwabeni Zungu, has disowned the document. He has virtually said, I have not made a statement. Therefore, it is very difficult to understand the approach that you must prove a statement when the witness has totally disowned it and actually said, I have not made a statement.
Yeah, it's quite interesting because, you know, the judge even highlighting that the witness has said he did not make a statement. How would that work?
But that is the difficulty that one sits with the context of this matter. The state is trying to use the statement merely to show that the witness, or to attack the credibility of the witness by showing that there exists a document that the witness has deposed to and which would be regarded as a statement. The defense, on the other hand, is coming up with a somewhat very difficult argument where they say you must prove that the witness made a statement when the witness has already testified under oath. I have not made a statement.
And let's talk about the ruling, the judge deciding to call the people that were allegedly involved in the alleged assault. And at the heart of it is him saying, we want to get to the bottom of this. We want to find out the truth. What benefits, if any, would the state get from like getting the statement in? But also, when you look at the witnesses that are called, what implications will it have really on getting the statement to be read?
The one must also then go back a little bit and remember that during the presentation of the state's case, the state did not have an opportunity to call witnesses that would have testified regarding the making of that statement, because the making of that statement was not material during the state's case. Now, the witness comes into the box and makes allegations which, at this stage, the state has not dealt with. And the decision that the court must make, obviously, as to the credibility of Sifiso Kwabeni depends on whether the court regards what he's saying as being correct or not. So the step that the court has taken of saying that it wants to hear the other side of the allegations which are being made by Sifiso Kwabeni in order to test his credibility as a witness in court, that is not problematic The only aspect that I think it's debatable is whether these witnesses must testify while Mr. Gwabeni is still being cross-examined, because if those witnesses testify while he's still being cross-examined, meaning that his cross-examination is paused. When his cross-examination resumes, the prosecutor will be able to cross-examine him, that is Mr. Gwabeni, on the basis of the witnesses, of what the witnesses called by the court under Section 186 would have said. So that is the only advantage that the state will gain from the procedure that the court has adopted now. The state will be able to take the materials of those witnesses and be able to cross-examine Mr. Gwabeni in relation thereto.
And like I indicated, in studio with me, I've got commentators, people who follow this case religiously, who, of course, have commentary every single day. We're also now joined by Mabelane, who's also a commentator. But I want to come to you, Bongani, about what happened this week. Just give us your thoughts about what you think, number one, about the ruling that was made by the judge. You are somebody that, follows this particular case. And just last week, we were talking about the issue around the proving of the statement.
It feels like we are robbed. It feels like, maybe let me say, it feels from a distance, it feels like someone is saving someone's career. Ne? I will say it feels like Judge Rata Mokhotleng is saving Advocate Baloyi's career. I mean, I can tell you now what is going to happen. They are going to bring in Brigadier Keninda and his crew. And I can tell you what they are going to say. And you'll tell me if I'm lying. They are going to say, we did not torture this guy. That's exactly what is going to happen. So whether you bring them or not, you can already tell what is going to happen, because we've been here before. Yeah. The accused laid almost similar allegations against the same investigation team. They were then asked, did you do it? They refused. So for me, it feels like the judge really is giving somebody an extended hand. Come save your career. He could have just simply made a ruling right there and then, say, okay, we've been there before, let's save time. Let's cut the call. Let's just save time. Let's cut this long one short. Let's go straight to the point. Are you accepting this as the gospel truth or not? Are you accepting what Gwabeni is saying or not? Right there. In fact, when you were, or as you were doing your research, as a person, as you were doing your research, you come across other case studies, which you think that it would have been nice if maybe the presiding judge would have followed those case studies, wherein a matter of a similar incident was in court and judges made a ruling there and there. Why not in this case?
Yeah. And let me come to you, Mabelane. I mean, you also, follow the case, and I think it's also important to point out that, in your daily commentary, the both of you seem to have taken a particular stance. Bongani, you believe the 5 accused persons that are in court are not the ones. And Mabelane, you believe that we have the right people before court. You've heard what Bongani has had to say. You've heard Kabelo in relation to the statement itself. But from your vantage point, what are your thoughts?
Yeah, Bongani, Linda, we are going to have a problem if we follow the general approach that my brother Bongani is following, because we must ask him, which case laws are those that he wanted Rata to have implemented? He must share them with us so that we interrogate them.
Definitely.
What were the merits in those cases? And then what were the judgments? He must educate us on that. Because Rata has made a ruling. And that ruling, Bongani, is supported by law. Section 186 says a court may subpoena a witness or cause that witness to be subpoenaed after it has applied its discretion. But in cases where the evidence is essential. That may is not, it doesn't apply. It becomes mandatory now. That section says, in such cases, the court must, in fact, they use the word, the court shall. They don't have an option. In this case, Rata, Gwabini is making allegations. Zungu Senior made allegations. Now, these are common allegations. The court says, I don't have any evidence or I don't have anything to evaluate to come to a conclusion. What must I do? I call the people to come and give their testimony, and I will then make an informed decision from that perspective. So, Rata is right.
And Kabelo, you know, the issues about testing the allegations. Talk to us about whether or not the statement of Gwabini is critical, because if you go back to what Brigadier Bongani Gininda said, he indicated that, for example, the name of Constable Sizwe Zungu would have come from those statements. He didn't know that Constable Sizwe Zungu was at the hostel. So would it still be important to get to hear this particular statement and whether or not it does in fact mention Constable Sizwe Zungu?
Linda, the point that was being made by one of your panelists is correct, in that the court here is sitting with the allegations that are being made by a witness. Now, those allegations are saying to the court, the evidence that you have heard from some of the key witnesses in this trial is incorrect because of these other happenings. But those happenings were not tested in the state's case. Therefore, the court is obliged to hear the evidence as to those happenings so that when the court rules as to whether it believes these witnesses or not, the court has had the opportunity of hearing the totality of the evidence from the witnesses that were party to those happenings. It cannot be that the court can rule on this matter without hearing both sides of the story with regard to those allegations. Now, going back, the evidence of Mr. Gwabeni is only material in that it must be tested against the evidence of Mr. Constable Zungu. Constable Zungu says we were together at the hostel, and Gwabeni says he was never there. Now, those two pieces of evidence must be put on the different ends of the scale, and one would then look for corroboration for either of the two versions. Obviously, Constable Zungu's version would be corroborated to a certain extent by cell phone records and will be corroborated by other material that has been adduced during the state's case. And one would then look at Gwabeni's end of the scale, where his version is a simple denial that he wasn't here. That is in line with the evidence of the accused. And that is what the court is going to have to weigh one against the other.
Yeah, and you know, let me come to you, Bongani. Your thoughts on what Kabelo has just told us now.
I have just one question.
Yeah.
Through you, as a lawyer, I would love to know this. We have seen this movie before on the Senzo Meyiwa case. And even in court, it was said that most of the time when you want the pocketbook from police, suddenly it's missing. We have seen it with the AVL record. As soon as you say, okay, let's go get the AVL record, guess what? The AVL record is missing. In this case, you're then going to say, oh, so we are going to test the allegation made by this man, right? So I want to know one thing. What if then, again, suddenly we hear the situation of Ms. Vittilingam from Vodacom versus Stein from the SAPS?
Yeah. All right.
Wherein the cell phone record is contradicting in this case. And now the state comes with a version that seems to side with their version, comes with a story that sides with them. Vodacom or MTN or whatever network comes with a different story in proving Kwabini's whereabouts and truthfulness of the statement. What if we arrive at the same situation we had when we were testing the allegation against the other accused through their cell phone records?
Yeah, parting shot, Mabelani, quickly, we've run out of time.
Yeah, definitely Bongani didn't understand the cell phone evidence. He's not saying exactly what he's saying. There's a difference between what you download from the cell phone and what you get from Section 205. Two different things. Let the witnesses come and give their testimonies, and then the court must be empowered to evaluate whether Kwabini made a statement or not. Thank
All
you.
right, those are my panelists joining us this week to unpack what happened in the Senzo Meyiwa murder trial. Like I indicated in studio, I'm joined by Bongani Masuku. He is a commentator who believes that the 5 gentlemen that are on trial are not the right people, but also joined by Mabelani, who seems to also believe that the people that are in court are the right ones. And to balance things out, we're joined by Kabelo Siabi, our usual analyst here, who helps us understand and make sense of why certain things happen in that particular case. But let's check in with the poll results now, and that's where we're going to be leaving it at. You recall that we were asking you questions in relation to the allegations of a plot to assassinate key role players in the Senzo Meyiwa murder trial. And of course, the options that we gave you there is that number 1, it must be taken seriously. Number 2, I don't believe them. Number 3, the trial should end now. And 71% of you, through scanning that QR code on your screen, said it must be taken seriously. 21% saying I don't believe them, as well as the last one, the trial should end now, being 8%. So those are some of the views that you've shared with us through that particular poll. But that's where we leave it at for this week. Court is officially on recess, and many of us are breathing a sigh of relief. This case will pick up again next January. And amongst the first witnesses expected to take the stand in relation to the taking of the alleged statement of Kwabini is the lead investigator, Brigadier Bongani Gininda. But until then, you have yourselves a beautiful week.